Good morning, all of you. So this will be our fourth lecture. In this lecture, we'll understand the concept of collective bargaining. We'll try to finish the whole chapter today only within 2 lectures. Okay. So in first lecture, we'll try to study collective bargaining, its definitions, its importance, its characteristics, and then we'll go on to the theories of collective bargaining. Okay. So first of all, I'll give you a brief review of what the chapter is, what are its major constituents, so that you get a brief introduction of what the chapter means to you before we'll go into deep. See, first of all, we'll be dealing with who coined the term collective bargaining, definitions based on power relationship, based on agreement. Then we'll go to the concept of collective bargaining, where how different emphasis on where different emphasis changes the definition or the main point of collective bargaining. Then we go on to the approaches of collective bargaining, where we'll talk about unilateral, bilateral, and tripartite. Then we'll talk about the characteristics of collective bargaining and the functions of collective bargaining. Okay. In this lecture, we'll do up to here. In next chapter, we'll start with collective bargaining in India, types of collective bargaining, collective bargaining theories. We'll cover all these theories. Lastly, we'll talk about the collective bargaining process. What are the important key steps within the collective bargaining process? And lastly, we'll do some MCQs. Okay. So let's start off our first lecture of collective bargaining. So collective bargaining, the term was coined by Sidney and Beatrice Webb. Okay. Their work was History of Trade Unions. In this, they coined the term collective bargaining. Now, what is that? What do we mean by collective bargaining? As you can see from the word itself, collective means there is something that should be of collective interests, and bargaining, there is a negotiation involved to get something. Okay. So let's understand what do we mean by the term collective bargaining. Okay. So collective bargaining is a process. Okay. We're talking about collective bargaining, which is a process to determine terms and conditions of employment. As we are talking about industrial setting, so here we'll just focus on that aspect only. So it is a process to determine the terms and conditions of employment, and also how to settle disputes. That there should be a manner in which the workers and management can settle disputes through negotiations between employer and employee. So it is a negotiation. It is a process where both parties sit together and chart out an agreement, where the agreement talks about the terms and conditions of employment, and it also talks about, in the event of difference of opinion, how do we tackle these issues? How do the management and the workers tackle these issues? Okay. So this is in crux collective bargaining. I hope you understand this. So now let's see what are the different definitions given by scholars with respect to collective bargaining. So this I have already told you. Collective, which implies group through its representatives. In industrial setting, group of workers is represented by trade unions. And bargaining, which involves haggling or negotiation. Okay. Now let's go to the definition of different scholars who have given the definition of collective bargaining. So first of all, based on power relationship and based on negotiation agreement. Negotiated agreement we've already discussed. then how two parties sit together to chart out the agreement where the conditions of employment have been discussed. But what about the power relationship? This we've talked about. If you remember that in Marxist theory, in industrial relations, we've talked about that the industrial setting is a class struggle between the management and the workers. There is a constant struggle and there's a constant fight for power. Who will determine what? So these definitions are also based on that. Similarly, more or less, but these are based on that. So first of all, we'll talk about how the Stevens talk about the collective bargaining. Stevens said this collective bargaining is more of a social control technique where the inherent conflict of interest between workers and management results into a basic power relationship. Okay. Similarly, Professor Alan Flanders mentions that it is a power relationship between management and workers where they both involve in a constant fight for their interests and they at the end settle with a compromise. See, this is a very key word. Compromise. This is a very important keyword. And you'll understand its importance when we'll discuss about various theories of collective bargaining. There, this key term will emerge out once again. Okay. So we've discussed the basic theories of basic definitions based on power relationship. Now we'll see definition based on negotiated agreement. First of all, Richardson, as a scholar, talks about the definition which is more or less related to what I have told you earlier, that it is a negotiating process where both parties sit together to chart out or reach an agreement over the terms of employment. Okay. Similarly, ILO, you should also learn about what the ILO says about collective bargaining. Okay. So it also similarly says that it is a process of negotiations about working conditions, terms of employment between employer and a group of employee or a one or more employee organizations with a view to reaching an agreement or a code of defining the rights and obligations of each party. So it means whenever there is an issue related to whatever agreed provisions that have been included in the code, there is a special provision. How do we deal with these? Similarly, these things do what? They actually apply rule of law within an industrial setting. So there's a very clear, like a constitutional document through which all the powers of these parties, these stakeholders are determined already. And so that nothing is remained to the discretionary power of both these parties. Trade unions cannot just go and do strike. Management cannot just do and unilaterally increase or reduce the wages of workers. Okay, everything has a procedure through which these parties act. Okay, now let's go to the next thing. Here we are talking about the concept of collective bargaining. In this portion, they are talking about that the collective bargaining is a marketing concept, is a government concept, is an industrial relations concept. And these things are based on the different emphasis within the collective bargaining setting. So if a person is focusing on market portion or an economic angle, he'll be calling it a marketing concept. If a person is focusing on the power relationship and the constitutional nature, it is calling on a government concept. And in the third portion, when it is talking about participatory decision making, then it is calling out industrial relations concept. Okay, similarly, we'll discuss each and every concept in detail. So first of all, marketing concept. marketing concept, collective bargaining is seen as a mode of negotiation that is solely focused on the economic aspects. What does it mean? That the management and the workers are involved in discussion of wages, bonus, benefits, which involve insurance benefits, provident fund benefits, even in festival settings, festival bonus like Diwali bonus, most of the companies give. So these, when we are talking about marketing concept, the focus is on solely economic aspect. Okay, so collective bargaining mostly involve these things. As we've already told you that it is a process of negotiating terms and conditions of employment. So within this process, the most important aspect for the both parties is economic. Okay, now let's move to the next concept, which is government concept. Within this government concept setting, collective bargaining involves the key term is power. Within this concept, collective bargaining talks about the power relationship between the stakeholders, between employees, employer, how they are interacting amongst each other, how they are involving, and how they are demanding their demands, where the workers are focusing on increasing their power. Similarly, the management also focus on increasing their power, and both actually wants the decision making power with respect to their core of interest, their area of interest. Okay, see, as you can see here, the governmental concept of collective bargaining regards the institution is seen as a political and power relationship. Okay, now we'll go to the industrial relations and managerial concept. It is a basic thing. This we've already talked about. Within industrial relations, it is a participative decision making. Understand this? Where both parties are engaged in a participative discussion and both try to come to an agreement where both parties' interests converge. Or they can come at a basic standpoint where both parties are either happy or both parties are neither happy, but they are at a compromise where both can work with each other. Okay, so this is the concepts of collective bargaining based on the emphasis they are focusing upon. If we are focusing upon economic aspect, so we'll call it a marketing concept. If we focus on power relationship, then we'll call it a government concept. And if we talk about the participatory decision making, then we'll call it a industrial concept or the managerial concept. I hope you get this. Although I'm going very fast, but these things are basic, and I'm going this fast because we'll go straight forward to the theories portion. But before that, we have to understand the basic theoretical concepts of collective bargaining so that we get a clear picture of collective bargaining. Similarly, how did we do in industrial relations? In industrial relations, we've talked about how did we understood industrial relations, and because we had a good understanding of industrial relations, we was able to easily understand what the theories talked about, because the theories were only talking about different angles of the same concept that we've discussed initially. So similarly here, if we understood the collective bargaining concept, whatever approaches and whatever theories we'll talk about by different scholars, so it is just a tangential aspect of the basic definition only. Okay, so let's go to the approaches of industrial concept. Check about this once again. So here we are talking about three approaches in industrial concept. So what are these three approaches? Just have a look. Unilateral, bilateral, and tripartite. Based on the names, you can tell that we are talking about something like one party, two party, three party. Okay, so the concept is similar only. Collective bargaining, as I've in the definition I've told you earlier, that involved negotiation between employee, employer. So these two parties, there were two parties that were involved in negotiation. Okay, so based on this, we can say it is a bilateral approach to collective bargaining because it involved two parties. Similarly, if suppose I remove employee, only employer remains, and he or she or it directly, without involving workers, prepare terms and conditions of employment. Prepare terms and conditions of employment without involving the workers. So in this manner, we call it individual bargaining or unilateral approach to collective bargaining. Did you see that? And now we'll go to the tripartite. Tripartite. Approach to collective bargaining. In this approach, as you can see, we're talking about three parties. Employee will be there, employer will be there, and suppose I bring in another party, suppose government or adjudicating authority, which can either be courts, tribunals, all three parties are involved in a negotiation. Here they three can sit up and talk about what are the basic minimum wages, because government sets minimum wages. Based on that, these people also functions. So this can be a single approach. Another approach can be when employee, employer, and an adjudicating authority involves in negotiation, because suppose if they both have some issue with a particular provision, this authority can interpret that provision and give a clarity to these two people. So in this manner, collective bargaining is a tripartite approach, okay, because it involves three parties. So we've discussed that collective bargaining can be understood based on the parties, and collective bargaining can be understood based on the emphasis on which we are talking about. Okay, I hope this is very much clear to you. Now we'll talk about a little bit about characteristics of collective bargaining. So this will be a basic, it will be like a features of collective bargaining based on the definition that we've talked about initially. Okay. So collective bargaining, it says it is a process in the sense that it consists of number of steps. Obviously, within a process, when we are doing something, it involves a set of steps in a chronological order that we do to achieve a particular goal. Okay. Similarly, it says that it begins with presentation of the charter of demands of the both parties. Both parties come together. Suppose the management comes and the workers union come, they both present their demands and both sit together, both engage in a brainstorming session when both are discussing that this can't be done, but this can be done, this can be done. How do we find a creative solution to all our issues? And then they both reach out to an agreement where the byproducts are harmonious relations between two parties. Otherwise, if they don't reach an agreement, both parties will involve in a constant conflict. Okay. See, it is saying that negotiations forms an important aspect of process of collective bargaining. This we've already discussed. Without negotiations, both can't tell their issues, both can't see each other's basic context, basic pretext from where they are coming, from where, what are the basic goals and ambitions of management, or what are the basic goals and ambitions of workers union. See, it is a group process. Obviously, it is a group process because it involves a workers collective group and it involves management group. Sometimes it also involves management. I'm sorry, not management, the government, also Supreme Court adjudicating authority. So it is a group process where all these groups sits, not individual. No one person from management will come. No one worker will come. Okay, it is not about one worker, it is not about one person from management, or it is about a group of people. Okay. Now we are talking about collective bargaining is a formalized process. Why it is formal? Because both parties are sitting on a negotiating table where they are actually formalizing the rules and regulations of employment, as well as the special provisions where it tells about if there arise any dispute, how we will resolve it. There is a very formal process to it. If these processes won't be there, how they will do? They'll incline towards the discretionary power of each and every individual within the group. Suppose if trade union member talks about that I want to increase my wage, not only mine wage, the whole workers' wage. So how we will do that if we don't have a special provision? How do you go to the management and discuss about increasing the wage? If there is no such provision, he or she will just do strike. He'll just resort to radical methods because the management also won't be listening, because management also doesn't have a provision that how do we deal with the workers. Okay, so these things will reduce productivity and will increase the cost to the company and will reduce the growth of the industry as well. So obviously it is a formalized process. It involves rule of law. It is a bipartite process. Obviously, employer and employee involves in a negotiation because they both are parties to them. It is a complementary process. Complementary process, what do we mean by that? That if I want to give something, obviously in return I'll get something. See, each party needs something and what other party has. Labor can increase productivity, and for that productivity, the management can pay better for their efforts. See, these both activities are complementary to each other, and that's why it is said that collective bargaining is a complementary process. Now, collective bargaining tends to improve the relations, and obviously this is a very established fact that when both parties are arrived at a conclusion where both parties can, both parties have achieved their interests, so obviously there is no point of contention, no bone of contention, then why will the relationship between these two parties will be solved. Now it is said that collective bargaining is a continuous process. Why? Because an agreement reached at the start of year can become obsolete after 2 years or after 3 years because of advent of technological world that we are living in. Even the constitution provides the special provisions for amendment of it. Although we have a very good constitution, but still constitution wants itself to become relevant with the changing world that we are living in. And especially with the arrival of technologies like artificial intelligence, machine learning, blockchain technology, the nature of industrial relations will keep on changing. And for that, we need to have a process of collective bargaining where workers can renew their roles and responsibilities within an industrial setting. Okay, so that's why collective bargaining becomes very important. It is a formal process where both parties can sit. See, collective bargaining takes into account day-to-day changes, policies, potentialities, capacities, and interests. It is a political activity frequently undertaken by professional negotiators. And obviously, these are the basic specific things. We'll not go into details. Okay. Because nor it is relevant to our examination. We'll just focus on what are the functions of collective bargaining. So let's understand what are the functions of collective bargaining. In this process, we'll talk about Professor Arthur D. Butler, who has given 3 functions of collective bargaining. First of all, he talks about that collective bargaining is a process of social change, and then he talks about it is like a peace treaty between the stakeholders, and lastly, he talks about it is a system of industrial jurisprudence. See to it, have a look at it, try to understand this, try to see what you can make of these things. Okay, so initially it talks about social change, means something like whatever is inherent in the society or the power relationship between two stakeholders. More or less, we'll be talking about that only, and this we've already talked about in the definitions of Flanders and Stevens. In the next process, it talks about peace treaty. Peace arises when both parties are happy with each other. And system of industrial jurisprudence. Jurisprudence is something related to legality. So it will be something related to law of formal provisions. So as you will see, when we'll talk about all these functions, that more of these things are that we've already talked about. These are just to mold that whatever we have discussed has been arrived. Okay, let's see. First of all, social change. Why social change? See, as workers are growing economically, politically, economically due to increasing wages, politically because of the growth of trade unions, because they are represented by trade unions. They also want high status within industrial setting. High status, political power, how will this come? Because these status and political power is fundamentally related to decision making. Before trade unions, before workers got their rights, management were solely the key decision maker. Management decided what will be the wages of workers, what will be the working conditions within which workers will be working, and what will be the holidays, what will be the method of increment, what will be the appraisal parameters. The sole authority was management. You get this? But now when there is a growth of trade unionism within our country, and this is not new, has been growing since mid 19th century, and then there is a economic growth and social status have increased within the society of workers. So workers also want a position, or you can say a platform on a decision making table, at least in areas that are core to their interests. What are those areas? Obviously wages. Wages are basic thing. Working conditions. Then we'll talk about benefits, social security. See, workers only want one thing, that whatever interests, whatever decisions that a management is taking with respect that is directly affects our interests, we should also be at the decision making table. That as we are living in a democracy, we are in a rule where people are supreme. Okay, so in that case, in industries also there should be industrial democracy, where if the decisions are impacting any stakeholder, that stakeholder must be consulted before any decision should be taken. That's what workers want, and within that process, collective bargaining helps. That's why it is said that collective bargaining is a process of social change, because it changes the nature of workers' positions. See, collective bargaining enhances the social status of working class in society. Wage earners have enhanced their social and economic power. Employers also retain high power and dignity through collective bargaining. It is a process that involves both parties to enhance their status. Okay, nobody's status is actually going down. Management, if management helps workers improve their dignified existence, then the management will also have a goodwill, because as you have within India, we say the Tatas do take care of their employees very good, because the management treats these workers as a part of the community, not like some other group where there is a constant struggle and there is a constant conflict of interest. Okay. Now we'll go to collective bargaining as a peace treaty. Obviously, we've discussed that both parties, if they agree on an agreement and both parties have discussed their issues, then obviously both parties can come at a conclusion where both parties are happy. And if both parties are happy, industrial setting is a peaceful arena. Peace treaty. Employer, they've agreed on wages, working conditions, working hours. If both have agreed on these provisions, if both have agreed that, okay, now we'll follow this agreement, then obviously both parties are happy. This will result in efficient production. High morale of workers. Understood? And the positive aspects that we've already discussed in industrial relations, that how a high morale and positive environment within an industry increases production and increases both workers' interests as well as employers' interests. Okay. Now we'll talk about collective bargaining as an industrial jurisprudence. Here we said that collective bargaining creates a system of industrial jurisprudence. What is industrial jurisprudence? That it provides civil rights to the workers. It provides civil rights to the workers. It establishes a system where the functioning of an industry or functioning of between employers and workers works with a set of provisions that both have discussed upon. This we've already talked about, that this was rule of law. In polity, you must have learnt about this, that there will be no arbitrary means without thinking, discretionary. No arbitrary decisions will be taken by both parties, neither by workers, neither by trade unions. So established rule of laws will be applicable within an industrial setting. So this is collective bargaining as an industrial jurisprudence. Okay. In addition to these above functions, it also serves as collective bargaining also serves various other functions. We'll see to that increasing the economic strength to both employers and employees. Obviously, when both will sit at a negotiating table, workers will get something, and obviously when workers will get something, the morale will be high, the productivity will be high. So in result, the employer will get something, profit, improving working conditions and fair wages. Yeah. This is justified. We've already discussed these things. Prompt and fair redressal of grievances. And see, if we have provided a proper method, suppose if we face something, somebody has done something illegal to us, so we have a process that we can directly go to the court. We have a designated authority that we can approach, that can resolve our issues. So in similar manner, having a set of conditions, having a set of provisions, enable the workers and also the management to redress their grievances. Okay, and this will be beneficial for both parties. Promoting stability and prosperity to the industry. Obviously, when both parties will have a normal functioning, high morale functioning, then the industry will inherently grow. Okay. Now, the constitutional guarantee we're talking about, it talks about that Article 19(1)(c) provides a freedom to form associations or unions. This gives, but obviously this Article 19 is not an absolute right. It is a qualified right that it is subjective to some conditions. In this All India Banks Employers Association versus National Industrial Tribunal, Supreme Court clearly mentions that it is not even in the liberal interpretation of this right doesn't allow workers to have a right to strike. That's why we also learned that Article 19 does not involve right to strike. This question have been asked in civil services examination previously too. Okay. Now, what about collective bargaining in India? Has India talked about collective bargaining? Has India mentions about collective bargaining? Let's see to it. The second 5-year plan. See, even after independence, we directly went to the process of collective bargaining. It says that for the development of an understanding or an industry, for development of any industry, industrial peace is indispensable, obviously. And how we will arrive at a peace? Best solution to common problems, however, can be found by mutual agreement. Although the second 5-year plan didn't explicitly mentions about collective bargaining, but the substance of whatever they were saying at that point of time was related to collective bargaining, because it says that both parties must sit together, have a mutual agreement, negotiate with each other, so that industrial peace is available through which the industry can actually grow. Okay. Now, let's talk about what the fourth 5-year plan mentions. The second 5-year plan didn't mention explicitly, but this plan did mention it. It says greater emphasis should be placed on collective bargaining and on strengthening the trade union movement for securing better labor management relations supported by recourse to large measure of voluntary arbitration. Okay, so you can mention about these things, or you can learn about these things, that second 5-year plan and fourth 5-year plan, especially the fourth 5-year plan, explicitly mentions about collective bargaining. This can be an important question. Which plan mentions about collective bargaining in India? Okay. So we have discussed the basic foundations of collective bargaining. We have discussed the conceptual framework of collective bargaining. Okay. In this lecture, we'll just stay here. In the next lecture, we'll talk about the most substantial aspect of collective bargaining, which involves types of collective bargaining, which involves the process of collective bargaining, which includes what different steps, and lastly, the theories of collective bargaining. Okay. So you can have a look at it. See, the most important aspect for any examination is understand the key definition, understand the key concept through which you will be able to deal with any question that comes to UPFO, because EPFO, because you have a greater understanding of the collective term. Then through based on different emphasis, these definitions are given. Learn these scholars, learn these key terms. Scholars, key term. Especially learn this definition, have a look at it. It becomes important because ILO is a very prime international organization with respect to industrial relations, with respect to collective bargaining. Based on different emphasis, we've talked about different definition or conceptual approaches to collective bargaining. Based on party, it is different. Learn about these things. This is although self-understood, but please do have a look at it. Similarly, characteristics. See, all these things now, you can easily, through basic inference, you can see, understand that if the question says that it is an informal process, then you can easily cut it, because it is not an informal process. In this manner, only the questions will come. It is not a complementary process. It doesn't improve the relationship. If you have understood the concept, you can easily relate what are the characteristics of collective bargaining. Similarly, Do remember the name of the scholar who has given the functions of collective bargaining, Professor Arthur D. Butler. Process of social change, peace treaty, industrial jurisprudence. Do remember this. This will come. Okay, if not this year, some year, because these questions are due. Collective bargaining, although has a very low, sorry, has a very low in terms of theoretical aspect, but through theories, the questions will come. Okay, learn about the 4th 5-year plan also. Okay, in the next lecture, we'll start with theories. Thank you so much.